all. This is Dr. Mobeen Sayed from drbeen.com. Welcome to one more show. So continuing to highlight some of the legal matters, today is Department of Defense and a couple of legal cases that were filed against the Department of Defense by service members who were required to have vaccination or be discharged. So that is a basic discussion. I'll hope that Paul will then, for us, keep track of these 3-4 cases that we were looking at and any more. So we'll discuss more in detail with Paul. I'm just going to highlight what is happening here. So the interesting news today is that Department of Defense has actually settled it before letting the case go all the way to Supreme Court. So let's look at this case together, or cases. So this is drbeen.com. If you are interested in medical lectures, then this will be the best place to go to. And there is a link in the description for a 50% discount. If you see here the plans page, there is a 50% discount to this in the link in the description. Okay, so let's check this out. So first of all, Austin ends the military's COVID-19 vaccine mandate. So this is, so here is Lloyd J Austin. He's the Secretary of Defense. Lloyd James Austin III was sworn in as the 28th Secretary of Defense on January 22, 2021. And before I show that he ended this, there were vaccine mandate or requirement orders which were issued on August 24, 2021 and November 30, 2021. So 2021. That is when these orders were issued, and then January 10 of 2023 is when these orders were rescinded. So here is his letter where, and my apologies for this incorrect highlighting, Adobe did something. So the department will continue to promote and encourage COVID-19 vaccination for all service members. The department has made COVID-19 vaccinations as easy and convenient as possible, resulting in vaccine administered to over 2 million service members and 96% of the force, active and reserve, being fully vaccinated. Then on December 23, 2022, the James M. Inhofe National Defense Authorization Act for fiscal year 2023 was enacted. Section 525 of the NDAA for FY 2023 requires me to rescind the mandate that members of the armed forces be vaccinated against COVID-19, issued in my August 24, 2021 memorandum. And the memorandum was titled Mandatory Coronavirus Disease 2019 Vaccination of Department of Defense Service Members. I hereby rescind that memorandum. I also hereby rescind my November 30, 2021 memorandum, Coronavirus Disease 2019 Vaccination for Members of the National Guard and Ready Service. So then he continues and discusses the rescinding of this order. So now if we go back here to the news, so this is militarytimes.com. This is the news about it, that Defense Department will no longer require service members to get vaccinated for COVID-19, according to a memo signed Tuesday by Defense Secretary Lloyd Austin. Now, to the cases. This is Monday, October 9, this year. So DoD settles COVID vaccine mandate lawsuit for 1.8 million. So this is a settling of the lawsuit, not winning or losing. This is a compromise between the two parties, and this 1.8 million is primarily for the lawyers' fees. So 2 lawsuits filed by service members challenging the Defense Department's now defunct COVID-19 vaccine mandate have ended in a settlement, according to an agreement filed Tuesday in a Florida federal court. So there was one lawsuit filed in Florida and another in Texas. A judge awarded Liberty Counsel, that was a firm representing plaintiffs, in Navy SEALs 1, 26 versus Biden and Colonel Financial Management Officer al. versus Austin, $1.8 million to cover legal fees incurred during the cases, which were filed following Defense Secretary Lloyd Austin's fall 2021 announcement that the COVID-19 vaccine would become mandatory for all troops. So fall 2021 is when these were filed, and here October is when these are finally settled. So it continued from 2021 into 2022 and almost near the end of 2023. So some more data here. Of 17,000 service members who refused the vaccine, according to data provided to Military Times in early 2023, more than 8,000 were discharged, and another 1,000 received exemptions before the mandate's decision in January left the rest off the hook for punishment. Now, involuntarily separated troops who mostly received general discharge are able to upgrade their discharges by filing with their services board for correction of records. Those troops are also able to rejoin the military. So this is the basic gist of the discussion today. Here is the settlement. So fee settlement agreement and release. And if you see here, by and through their respective counsel, plaintiffs in Navy SEAL 1 and plaintiffs in CFMO, and defendants Lloyd J Austin in his official capacity as Secretary of Defense, and so on. So there were two basic service members who started the suit, and then I believe another 60 joined them as well. So if you see here, defendant, that is the Navy and the US government, defendants shall pay plaintiffs through undersigned counsel $1.8 million for attorney fees, costs, and other litigations expenses reasonably incurred in the civil action, the settlement payment, including $900,000 for fees, costs, and other litigation expenses incurred in Navy SEAL 1, and $900,000 for fees, costs, and other litigation expenses incurred in CFMO. So that is the basic structure, and they continue on. You have the links in the description. You can read these. Now back here, some more color. So this is it. This is the discussion. If you just wanted to hear what is happening, there were cases filed in 2021 by 2 service members, then they became 60. They went all the way to the federal court. Federal court wasn't very, very happy with what was happening. There was a religious exemption that was asked for, and some members were getting the exemptions and some were denied the exemptions. And not only that, they were being discharged. So eventually, judge put an injunction, and while that was happening, came around this January 2023, where the order was rescinded, and then the cases are settled. So this is the discussion. Now let's very quickly look at some details. So this is judge temporarily bars military from punishing 2 officers over vaccine refusal. This is February 4, 2022. In a stinging rebuke of the military's handling of the mandatory COVID vaccine enforcement policy, a federal district court judge in Florida has issued a temporary order preventing disciplinary action against 2 officers who refused the vaccine on religious grounds. So this is how it started, from these 2. The military is well aware of the frailty of their arguments in defense of their practices. Federal District Court Judge Stephen Merriday ruled in his February 2 court order. The record creates a strong inference that the services are discriminatorily and systematically denying religious exemption without a meaningful and fair hearing. In a separate case, a Texas judge in January ordered a temporary injunction against the punishment of a group of Navy SEALs, the Washington Post reported. Then the ruling came after a motion for a preliminary injunction on punitive actions was filed on behalf of Navy commander who commands a guided missile destroyer and a Marine lieutenant colonel who currently served as a diversity and inclusion officer at Marine Forces Special Operations Command and is slated to take command of a combat logistics battalion this summer. They were not disclosed at who they are. Then some more data. I have highlighted those areas that are of interest. Of course, I'll request you to read the whole sections of the articles. Mary Day additionally argued that removing the two officers from command would be a loss both financially in the taxpayers' investment that has been made in their career and to the military, which benefits from their skills and experience. The public undoubtedly has some considerable interest in maintaining the service of skilled, experienced, highly trained, patriotic, courageous, and esteemed service members in whom the public has an immense financial investment and who are not, to say the least, readily replaceable, Mary Day wrote. The Secretary of Defense and anyone acting in concert with him is enjoined through February 11, 2022, from diminishing or altering in any manner and for any reason the current status of the officers, including their assignment, privileges, rank, or the like. The Navy officer who has more than 17 years in service submitted a religious accommodation request September 13, which was denied in October. The ruling noted, however, that the denial letter made no mention of the fact that 270 other exemptions had been approved, seemingly negating the logic of Gilday's reasoning, the person who denied. The Marine officers originally requested a religious exemption September 7 and received her denial in October. Her subsequent appeal was denied in January by the Assistant Commandant of the Marine Corps, General Eric Smith, who questioned whether the vaccine would truly burden the officer. Following the second denial, she was ordered to begin a vaccination series no later than Feb 2, this is 2022, or face being placed on the officer disciplinary notebook. This would result in stripping the Marine officer of her command as well as her eligibility to deploy, be promoted, or work toward retirement. Then, this is February 18, 2022. Could the Supreme Court strike down the military vaccination mandate? More than 60 servicemen. So what happened was these two were then joined by more than 60 service members. And there are some interesting points here as well. The goal, representatives for the plaintiffs, the military members, say, is to at least secure religious exemption for their clients, but potentially see a Supreme Court ruling that would apply to all service members. So this Supreme Court ruling did not happen because the parties have agreed and settled before. Both cases are in a wait-and-see phase, where judges have granted injunctions against any discipline for vaccine refusal, while the government responds to requests for information. The Justice Department intends to appeal the Texas ruling, while a temporary injunction in Florida case expires Friday. Now, I want to read this here, which is interesting. And I remember I had talked about this a lot, including, I remember so clearly that I made a video talking about the religious exemptions or religious objections to the vaccine and the reason for the objections, the fetal cell line, etc., and various church heads or their messages. And I was pushed back so hard that who the heck am I to talk about Christianity or the belief system there, and while I'm not a Christian myself. So that was funny. I have that video still up. So here, their objections to the vaccine fall into one of four categories, according to their complaint, including opposition to abortion and the use of fetal cell lines. So that was one. That was very common objection in the days when vaccines were known to have been either designed and built in the fetal cell lines that were harvested from aborted babies, or they were actually built into, they're manufactured in these cell lines, and then those cells, so the cells are cultured and grown, and inside those cells are these adenovirus-based vaccines that are created, and then adenovirus are taken out and the cells are destroyed. So first one, including opposition to abortion and the use of fetal cell lines in pharmaceutical development, belief that body modification violates their religious principles, direct divine instruction not to receive the vaccine, or declining to inject trace amounts of animal cells into one's body. So these were some of the 4 main objections on a religious ground that people had. The primary protest centers around fetal stem cells, which may or may not have originated with an aborted pregnancy. And I have done detailed discussions, hours-long discussions, many discussions about these, at how these cells were brought together. There were cells from the embryonic kidney and other parts of the body, from 2 aborted fetuses. So the law says that sincerely held religious beliefs are to be taken at face value. The judge agreed, assuming an injunction against discipline for the sailors on January 3. The government has since filed a notice that it plans to appeal the decision. The Texas lawsuit argues that the Navy Department is blanketly denying all religious requests, making the process a sham. So then I thought this was interesting. This is the data in Military Times. According to data submitted in Florida case on Feb 88, the Air Force Department had received more than 12,000 religious exemption requests, denying over 3,000 of them, and with roughly 2,000 still in adjudication. So that is Air Force. Total exemptions granted in the Air Force included about 1,500 temporary medical exemptions and 2,300 administrative waivers, which includes the 9 religious approvals. In the Navy, none of more than 4,000 religious exemptions had been approved. That's what the objection was, that in Navy, it seems like everybody is just simply being denied. But there were about 252 temporary and 11 permanent medical exemptions. The Navy granted another 500 administrative exemptions, including temporary waivers for sailors planning to leave the service or in the middle of a permanent change of station move, for example. The Marine Corps had fielded 3,500 religious waivers requests, granting 3 in addition to about 250 medical waivers and 400 other administrative approvals. The Army reported about 1,300 religious requests, none of which have been approved, as well as 6 medical exemptions. So this was interesting for me. Air Force had the highest number, and then they also had a lot of approvals as well, and denials too. And then Navy did seem like none of more than 4,000 religious exemptions had been approved. So this statement over here, the Texas lawsuit argues that the Navy Department is blanketly denying all religious requests, making the process a sham. And then this was the January 10 rescindment or rescission letter, which I had shown you before, and this is the fee. So here is the discussion. Of course, it is interesting for me that the case got settled and was not gone up to the Supreme Court. Otherwise, there would have been some further clarity that may have sustained for a longer period of time. But anyways, now that the mandate is not there anyways, in October, they have settled. This is the discussion for today. I hope you are having a good day. I will speak with you tomorrow, and I'm going to put this back with Paul. Paul Bork is here in the talks. Paul, with your permission, I'm going to show your comment here. So you're talking with someone else, LL Cool Bean. It would be good if hospitals and others are sued and lose for firing others. So that is the interesting thing. For me, what was interesting was were there discharges from Navy, or not Navy, armed services, where they were not generally discharged or honorably discharged? And it seems like there were some. So they were then allowed to come back and get their record corrected. And secondly, they were allowed to come back and become or join the services again. This is in contrast to the LA Unified School Department. And I understand you're saying, what are the two organizations you're comparing? One is a very sophisticated, different organization, and here, LA Unified School District. So LA Unified School District said that we are not going to reinstate the members, but they can apply again. I think that is the same message from the Army as well, or the military as well, that they can reapply. So that was interesting for me, that their discharge records will be converted to general if there was something else. So this is the discussion. Thank you very much. Please like, subscribe, and share. The links are in the description for these talks. Plus, if you would like to go get access to Drbeen, the links are there as well. And if you would like to support this work, the links are there too. Thank you, and I would see you tomorrow.